Of course, we welcome your comments and whatever suggestion you may have for this afternoon on all the matters that we are dealing with this afternoon here on the pause. Now, let's talk about what happened in court this week. Now, legal opinions are divided on the Supreme Court judgment that declared the Speaker of Parliament's decision on the 4 vacancies as unconstitutional. The Apex Court yesterday provided a detailed explanation for his decision to uphold a suit brought by the Majority Leader, Alexander Afenyomarkin. According to the Apex Court, a member of Parliament is deemed to have vacated his or her seat if they change their political affiliation and continue to serve in Parliament under a new party identity. Member of the panel of judges that decided the Afenyomarkin case on the interpretation of Article 71(1)(g) and (h), Justice Ahmadu Tonko, has cut through the judgment of his colleagues, describing this as an aberration of the known rules of the Superior Court. A member of our legal affairs team, Koko Asante, joins me in the studio as we unpack the reasoning of the court. Also hear from the Attorney General. But first, Koko, you're welcome.
Thank you, Alte.
So first, let's start with the reasons provided by the majority group on this panel.
Yes, Yao Dakwasari, Justice Yao Dakwasari, appointed to the court in 2019, wrote the lead opinion for the majority, 5 of them. Yao Dakwasari himself, Justice Tokunu, the Chief Justice, Justice Samuel Adibu, Maria Mousu, they formed the majority on this matter, NS Yao Gayewu. They said that for a member of Parliament, on a ticket of a political party to be said to have vacated his seat, that person must not only evince an intention in the future to contest on a different platform, but in the current Parliament, that change must manifest itself. So when it comes to, say, the Member of Parliament for Suhum, the Member of Parliament for Aguna West, and the Member of Parliament for Amenfi Central, not only should they say that they are changed in circumstances for the 2025 Parliament, but that currently in Parliament, they are no longer NPP MPs and are independent MPs. If they say they are independent MPs currently, that is the ground on which they will lose their seat. Let me quote. Right. It says, in the result, we hold that upon a true and proper interpretation of Article 97(1)(g), the legal elements of that provision can be formulated as follows. I, an MP must vacate his seat. 2, if he leaves the party under which he was elected to join another party or become independent and seek to remain in Parliament under that new political status. And then similarly, they do talk about 97(1)(h), where they say an independent MP must vacate his seat if he joins a political party in Parliament and seeks to remain in Parliament under his new status. So they go ahead to list a number of members of Parliament who in the past actually did change the political platform and still remain in Parliament. Honorable Gladys Nsua in Kintampo, he sought re-election in 1996 on the NDC ticket, although he was NPP previously. Honorable Dr. William Makoto, he served as NPP MP for New Abrim between 2001 and 2004, and then retained his seat as an independent MP. Joseph Osewusu, the first deputy speaker we know, he was an independent MP for Bekwai from 2009 to 2012, and then later contested the 2012 election on the ticket of the NPP. So they go on, and they say that the reasoning behind the Speaker's declaration and its reading of Article 97(1)(g) and (h) is vitiated by the fact that it seeks to effectively rewrite the 1992 Constitution by positioning political parties as de facto owners of parliamentary seats. According to this majority opinion, if the Speaker's opinion should hold, political parties will now be the ones who own the seats, and they can decide that this person has left our party, even though he's still caucusing with us in Parliament. We have decided to take him out, and that seat is lost. And so the majority, in this opinion written by Justice Yao Dakwasari, say the Speaker's formulation of Article 97(1)(g) and (h) was wrong.
And then the others, the two, that took a different position. Right.
It started from Amadou Tanko GSC, and in fact, he started right at the outset declaring war. He said, I quote, I do not hasten to proclaim that I've apprehended with despair the majority's conclusion in this suit, but I state with utmost deference to the Honorable Chief Justice and the rest of my brethren in the majority that not only do I fundamentally disagree with their conclusion, I, with all due respect, also find their decision an aberration to the established and accepted judicial position of this court, with which, with profound respect, I hope in no distant future, the resultant usurpation of the constitutional prerogative of the High Court, incidental to the majority decision, will be reversed. And we should clarify that Justice Tanko is not necessarily disagreeing with the majority on the facts of the case.
Right.
He says, when it comes to this matter, the Supreme Court did not have the exclusive original jurisdiction. That is, the case should not have started from the Supreme Court. The case should have gone to the High Court. And if, by virtue of Article 131, there was an interpretation issue, the High Court would have stayed proceedings and referred the matter to the Supreme Court. The court would have dealt with it. He continues by saying that the present dispute, which invites the court to determine whether the seats of the MPs affected by the Speaker's pronouncement have become vacant, is vested in the High Court and not at all in this court by any canon of interpretation. By assuming jurisdiction in the court, this Supreme Court is rather usurping the special and exclusive jurisdiction of the High Court on the issue, a situation which in itself is per incuriam the 1992 Constitution and potentially unconstitutional. He held no bars there, really saying that the court should not have gone into this matter. The view was taken also by Justice Lovelace Johnson, who joined him in dissenting. And
then there's a part where he makes the point that maybe in the future this decision can be reversed.
Yes, he says that he disagrees fundamentally with the majority opinion, the view that was held by the Chief Justice and 4 other judges on the panel. He says he has such a fundamental disagreement with that opinion and that he hopes in the near future the same Supreme Court, because we know that the court has the inherent powers to go back on decision and all that. So he says he hopes that in the not distant future, this position that was taken by the Supreme Court will be changed. And I quote, he says, "I, with all due respect, also find the decision an aberration to the established and accepted judicial position of this court, with profound respect, I hope in the no distant future, the resultant usurpation of the constitutional prerogative of the High Court, incidental to the majority decision, will be reversed." That is Justice Tanko writing in that 109-page ruling that was published by the court yesterday.
And then there's also the other angle introduced by the Speaker of Parliament's lawyer, Thaddeus Sory.
Yes, Thaddeus Sory has taken to his Facebook page yesterday, together with Justice Sai, who formed part of the legal team for the Speaker at the start of this case. They say that if you read the Constitution, if you read the provision, the judgment of the court, there was no order directed at the Speaker of Parliament to do A, B, C, or D. Also, you will recall that when an initial 5-member panel of the Supreme Court voted to stay the decision of the Speaker, they made what is called consequential orders. They directed the Speaker to allow those 4 MPs to come to Parliament and do their work, blah, blah, blah. But this time around, the court stopped at saying that any interpretation that has been put on Article 97(1)(g) and H, that is not in consonance with the new interpretation this court has put on those provisions, is null and void. It does not mention the Speaker. It does not make any orders directed at the Speaker. Thaddeus Sory says, because of this, the Speaker of Parliament has no role to play in this matter, and that in fact, the court has not said that the Speaker of Parliament should perhaps admit those 4 MPs to come in. Let me quote part of what Thaddeus Sory has been sharing on Facebook since last night when the court did publish this. It says that Thaddeus Sory, in this opinion, says, in effect, all the court says is that the constitutional provisions in controversy bear the meaning they have put on them, without positively saying that they have declared the Speaker's decision null and void. There is no repetition of the ex parte orders that are marking God. It says again that, now let's remember that after the Supreme Court has made a declaration in the exercise of its original jurisdiction, it is required under the provisions of Article 2 to make such orders and give directions as it may consider appropriate for giving effect. There is no order, this is Thaddeus Sory speaking, there is no order saying that the MPs must be allowed in Parliament or order directing that Parliament recognize the said MPs as earlier ordered by the court, contained in the majority decision of the court. The order staying the execution of the Speaker's ruling is now spent. Also, we must say, although, that despite the court not having given that, in the Abu Ramadan case on the NHIS vote, the court did give a similar ruling of this sort. Abu Ramadan did go back to the court and ask the court to now make consequential orders. And the court did that on an expedited basis. So if the majority leader is so minded, he may do so to clear up this quote-unquote confusion that some persons have said has been caused by the judgment of the court.
Before I bring in the Attorney General, what are you getting from the majority side in Parliament? Is there any process to get a House in session?
We understand that the majority leader has been meeting with both the President and the Finance Minister in France. Over the last few days, the President has been outside. Majority leader has joined them, and they've had meetings. They will decide exactly what they want to do, especially because the finance minister has such a key role to play in this. The vote on account of the 2025 first quarter budget is also expected to come before the election or right afterwards. And it's barely 3 weeks to the December election. And so the decisions have to be made as to whether or not they will force the hands of the speaker to recall parliament between now and the 7th December, or they will allow the speaker to recall parliament on his own volition. And if nothing happens, perhaps force him to recall parliament. But as we speak, the decision will be taken between the majority leader, the president, and the finance minister, who are all outside the country now.
Okay, thank you very much for coming. And let me just, on page 36 of the court, the decision provided by the court, it concludes by saying that it is in the light of all the preceding discussion that this court determines that the plaintiff's suit succeeds on the merit. In the result, this court grants the plaintiff the relief 1A, B, and C, and makes the following orders. An order declaring the interpretation placed on Articles 97(1)G and H as inconsistent with the true meaning and import of Article 97(1)G and H of 1992 Constitution. And some say that this is enough order for the Speaker of Parliament to act accordingly. Well, in the last few hours, the Attorney General and Minister for Justice, Godfrey Abuadamen, has mounted a spirited defense of the Supreme Court and criticized one of the judges who dissented. He spoke on the Midday News this afternoon.
Specific relief sought by a party to the matter, and those reliefs were upheld by the court. If you look at page 36 of the judgment of the majority, that is the one authored by Justice Dakwasari, he made it quite clear that in light of all the preceding discussions, this court determines that the plaintiff's suit succeeds. And then he proceeds to say, in the result, this court grants the plaintiff the reliefs 1A, B, and C, and makes the following further order. An order declaring the interpretation placed on Article 97, Clause 1, paragraphs J and H as inconsistent with the true meaning and import of Article 97, Clause 1, paragraphs J and H of the Constitution. So clearly, the orders were made. And so we only have to look at the relief sought by the plaintiffs. The plaintiff's relief 1, which was granted in its entirety, was in these terms: a declaration that upon the true and proper interpretation of the 1992 Constitution, the light of Articles 2, 1, and all the other provisions that he states. A, the final nomination of Honorable Andrew Esama Amwako, the current independent member of Parliament for Formula constituency in the Ashanti region, with the Electoral Commission to contest the Formula parliamentary seat on the ticket of the MPP in the next or 9th Parliament of the Republic of Ghana, does not amount to vacation of his seat as a member of Parliament in the current 8th Parliament of the Republic of Ghana as an independent party to join the party. Then he repeats the same for Honorable Cynthia Morrison and Honorable Kojo Asante. So at least, in respect of these three members of Parliament, 3 distinct orders were made by the Supreme Court to the effect that the change of their political, or the anticipated change of their political identity for the 9th Parliament or the elections which will occur in December 2024 does not amount to a vacation of their seat. What does it mean? It means that they have not vacated their seat and they still hold on to their seats as members of Parliament. And that is quite clear. I mean, I think that we must stop this unnecessary resort to some ill-founded or artificial technicality. This clear artificial technicality, it doesn't arise at all.
Okay, so you
and if you look at Article 2, Clause 1 of the Constitution, based on which the Supreme Court made these orders, it says the court is the one vested with the sole and exclusive decision to interpret the Constitution and, of course, declare any act or omission on the part of a person as unconstitutional, and that the Supreme Court shall, for the purpose of declaration, make such orders and give such declaration. And such a declaration has been made. Such orders have been made by the court clearly.
So you insist you insist that the Apex Court gave effect to its orders, but is it executable? Is the question?
Why not? I mean, so if the court makes an order that A, B, or C persons have not vacated their seats, what does it mean? Does it not mean that they are still members of Parliament? Yes, they are still members of Parliament, and that is the whole import, the hope of the exercise that are taken by the Supreme Court. So I think that we must stop this unnecessary attempt to resort to some artificial technicality and say that there has not been no order made by the court. I mean, it's there in plain black and white.
So it's executable, but who is vested? Who is vested with the powers to execute this? As you're saying, you say it's executable. Who is supposed to do that?
So after the Supreme Court has stated that ex-member of parliament is still an MP and has not vacated his seat, what does the president have to do? The president has to just walk into parliament and go and sit and take his seat. And if there's an attempt to prevent that, that will then amount to a violation of the Supreme Court ruling.
So that's the Attorney General, explaining his position on this matter. Now, Parliament is still on recess, and it's unclear whether the Speaker, on his own volition, will recall Parliament to sit, or whether the MPP caucus in Parliament will trigger the necessary provisions in the Standing Order and, of course, in the 1992 Constitution to force the Speaker's hand to recall Parliament to sit, at least for the third time. That's, we are learning, is likely to happen early next week, because there are some key government business that was happening on the floor of Parliament, including the presentation of a mini budget, if you like, to take care of the first half, the first quarter of 2025, plus other key government business that they want to execute. Now, we'll watch this space carefully. President Akufo-Addo is in France. The majority leader, Alexander Federmarkin, is with him. Some discussions are ongoing. The Speaker, we are told, is also out of town. But everything will clear out, hopefully, early in next week. We'll deal with this matter more. But for now, let's talk about something that, for me, is good news. Now, the Ghana cedi is on a sharp rise against the major currencies in the last 5 days. It's been on a rally. Now, dropping from 17.2 cedis to $1 to 15.9 to the dollar as we speak this very afternoon, to the same currency this week alone. Now, in the studio with me is Isaac Kofi from our research desk to discuss what really is accounting for this massive show of force by the Ghanaian cedis against the major trading currency. And just not the dollar, is also appreciating against the British pound sterling and, of course, the euro as well. So, Kofi, Monday, for example, on my way to work, listening to the business news, and then the exchange rates, and it was over 17 cedis.
Yeah.
And this afternoon, 15.9. What is accounting for this?
Well, just like you put it, this is good news. Per the data that we've analyzed so far, this is the first time in a long time that the cedi is actually gaining close to about 3% against the dollar in just 5 days. This week alone, we can actually do a cumulative gain of about 3%. That is very, very significant and good for the health of the cedi. Moving from that 17 cedis, somewhere around 17 cedis, 20 pesos, 17 cedis, 50 pesos to now between 15 cedis, 90 pesos, and 16 cedis, 20 pesos. That tells you that that margin of appreciation, or that level of appreciation is very, very huge. Why is this happening? This happened just about 4 days after the Bank of Ghana decided to inject $240 million into the system to help those who are bringing in pharmaceuticals and all the other, imports into the country. And this has really, really helped the cedi to gain some sort of respite. Now, not just Bank of Ghana's current intervention, but we know what is also going on in the U.S., where
the Federal Reserve has cut down
24 hours,
interest.
yes, 24 hours after Donald Trump's re-election, we saw that the Fed decided to cut their monetary policy rate, which essentially means that supply is going to be available. And Bank of Ghana, did the intervention at the right time. And currently, we are seeing the cedi gaining significant values against the dollar.
Is this going to continue?
Well, continuation, we are not so clear. I mean, we are looking at the data, and the outlook is not really that clear. But for the cedi to gain 3% in just about 5 days, that tells you that, I mean, if demand pressures begin to slow down, which usually you have when you are getting to the end of the year, because of the hike in exchange rate, people would want to import, the last quarter goods somewhere around maybe September or August. They do it early so that when we get to the last quarter, they wouldn't have to battle with exchange rate situation. So that has actually eased the demand pressures. So if Bank of Ghana decide to still come in with their interventions, trying to put in more supply, then this might continue. Now, trying to use historical data to interpret this, we all saw what happened in 2022 when the cedi went as high as, I think, around 15 cedis to the dollar. And when we're just entering Christmas in November, we saw the cedi gaining value against the dollar, moving from that 15 cedis to somewhere 8 cedis, and it could even get as low as 7 cedis, 80%. We do not know if the same thing will happen this year, but what we are learning currently, or the data we are observing currently, is that the cedi is on a good run against the dollar.
So today is Friday, November 15th. So the Bank of Ghana started trading at 16.07 buying and 16.08 selling.
That's even interbank, right?
That is even interbank. Yes. And as we speak now at 3:23, it's below 15 now.
Below 15, absolutely. This is the first time the cedi is going below 15 in about 1 month. It has always been above 16. And I've called a number of forex bureaus trying to also check from some credible sources such as Bloomberg and some of the 23 dealer banks. And what we are learning is that this is actually very accurate. And this is a general sentiment currently very positive in the system, where the cedi is really responding to that intervention that the Bank of Ghana did on Monday.
But if the Bank of Ghana continues to pump in more dollars, I mean, the pros and cons for such an intervention.
Yes, I mean, there are others who argue that when you have the cedi appreciate in this manner, it is always some sort of artificial appreciation. We saw a similar thing happen in 2022. Especially, Bank of Ghana could have done this, and we heard the governor. He said, if I want to drive the cedi down to 7 cedis now,
you can do it.
I can do it. But the key question is, whilst you are doing it, what happens to your reserves? It was because of your depleted reserve that sent us to the IMF in 2022. So if you keep doing some of these things, what happens to that your reserve, which is just slightly above 3.2 months of import cover? Bank of Ghana will be worried, IMF will be worried, and we've seen the IMF program where the Bank of Ghana is actually precluded from actually doing some sort of these interventions on a regular basis. But I mean, 240 million in the last quarter really came at the right time, where there was rate cuts.
And then also, I mean, this week, for example, the head of the U.S. Federal Reserve says that they will do another revision, and the possibility of reducing interest by another 0.25% is very high. If the U.S. Federal Reserve continues on this trajectory, global currency, response, how would that, especially for developing countries like Ghana?
Well, once you decide to cut the rate, what happens is that you are making supply available. And that is really good for emerging and developing economies like us, So when US decides to cut another rate, it will be good. But it will depend on the magnitude of that rate cuts that the Fed promised investors, or the US, economic space, that they were going to do at least 2 rate cuts. And we saw the first one. They had them chasing the rate cut for more than 9 months before they did the first one in September. Second one has come through, promising a third one. It depends on the magnitude of the cut. But, I mean, whatever happens in the U.S. must be met by sufficient supply, right? So if U.S. still cuts and the available dollars doesn't find itself into our space, we do not get the supply, it will be difficult for us trying to plug some of the holes, especially if we talk about remittances, for instance, where between 2018 and 2023, about $12 billion of remittance that was supposed to come into the country, we could not account for that. All of these factors, if we're able to plug that hole, will help the cedi. We've seen a number of banks since, somewhat November last year, and now 4 commercial banks, 4 dealer banks have actually had their foreign exchange trading licenses suspended for about a month because of some of the breaches. And we also have a number of fintechs who have also had their, licenses suspended. So there are regulatory gaps, and it depends on how the Bank of Ghana will actually solve that when they are even trying to do some of these interventions.
I know we are talking about the dollar, but I'm also seeing that the pound sterling is also seeing a decline. Currently on the Bank of Ghana X space, they are quoting 20.4 for buying and 20.43 for selling. The same is going for the euro, even though the release spoke about dollar. How come it is also having an impact on the pound sterling and the euro?
I mean, it's a general sentiment. I mean, when the cedi is performing against a major trading currency like the dollar, it is somewhat automatic that you might have some of this, infiltration into the other trading currencies. But with the pound, it's still very high. 20 cedis to a pound is It's still very high.
Right.
But usually the reason why we talk more about the cedi is because of its universal nature in terms of trade.
The dollar.
Exactly. The dollar is because of its universal nature in terms of trade. So, I mean, it's good to see possibly all three major trading currencies. I'm talking about the pound, the euro, and the cedi, possibly all falling against the dollar.
And finally, before we go, we are in an election year. We are voting in the next, in almost, in some few days from now. I mean, how do you expect the cedi example to behave post the elections?
I mean, Bank of Ghana has been clear that they have what it takes to make the cedi very stable. And for me, the biggest worry is the fact that we could not get the 1.5 billion syndicated loan. If that had come in, we would have possibly seen a dollar to the cedi about, let's say, 12 cedis or 13 cedis at the moment. But because the syndicated loan, which used to come somewhere around September and November, didn't come through, that really tied the hands of the central bank. But the assurance is that they have the supply to meet the demand. And look, I mean, businesses forecasted, they knew that it was going to be tricky trying to bet on the last quarter, so they did most of their imports in the third quarter. That's good news for us. And in the current, the fact that we are about just 22 days to the elections, it is good that we are having some of these interventions. As to whether the Bank of Ghana will continue to do another intervention, that is a decision that they will take by themselves.
Well, thank you very much for coming through. And the news this afternoon is that the cedi started trading around 17 Ghana cedis, 20 pesos worth to the US dollar at the start of this week. As we speak today, Friday, it is now trading at 15.9. That's significant. And the reason has been explained. We'll take a short break here on the program. When we return, remember last year, the Asantehene Otumfo Osei II launched a $10 million fundraising activity to heal the Komfanoti Teaching Hospital. 1 year on, is the project done and dusted? Has it been handed over to the hospital? We'll have that response for you after the break.